Hello, everyone. Eric from Helps YouTube Live today on January 26, 2025. Trusting you can hear me okay. Good to have you here. Um, there we go. Good. So my name's Eric, attorney now for 46 years, the founder of Helps. Helps is a national law firm. What we primarily do is we represent seniors and disabled persons who have debt they can't afford to pay. And we do that to protect them from collector harassment so they don't need to be bothered by collectors anymore. And there's a federal law called the Fair Debt Collection Practices Act. Provides if you're represented by an attorney, collectors can no longer call or send you demand letters anymore. They have to deal with the attorney, and that's what Helps does. We represent seniors who owe debt so they don't have to deal with collectors anymore. So we do this YouTube. Our next mission is to educate seniors how they can maintain their financial independence, and that's why we have this YouTube channel. So if you have any question, you can put it in the chat feature. Should be able to answer it there for you. But then I have a lot of things written down that people have asked us either today or last week, or emails and stuff like that clients called. So this person from Missouri called and says, it says, I have a payday loans that have been sent to collectors. They keep moving from one collector to another. It's very confusing. I have credit card debt. It is all spiraled. Well, okay, so what we're going to do is call this person back, and if they're on Social Security or a pension, which I assume they are, that's why they called us, we're going to tell them that their income is protected and that they could stop paying the payday loan. Okay, and as far as the credit card debt, they could stop paying that too. If they enroll in Helps, then we're going to send a letter out to those collectors. We're going to leave them alone. Now, as far as the payday loan, see, the Fair Debt Collection Practices Act, that law is a federal law passed in 1978, and it applies to original creditors, the person you borrow the money from. It applies to debt collectors, not original creditors. So if you have an original creditor like a payday loan, theoretically they can still call you, and they will. Even we still send a cease and desist letter out to an original creditor, including a payday loan. If they turn over collection, then they legally can't call you. But sometimes payday loans, they violate the law. And if they're an original creditor, if they're the original person you borrow the money from, it's in most states it's legal for them to still call you. Now you don't have to talk to them. If you enroll in Helps, you give us their name and number, their name and their address. We're going to send them a cease and desist letter. But they still legally could call you on the phone. But if you could take steps you don't need to talk to them. If they call you, tell them you're represented by an attorney, give them our name and number, and hang up the phone. You don't need to communicate with them. Now, once in a while, people will get a payday loan from an Indian reservation or overseas. The reason they set up an overseas or on Indian reservations is because sometimes they could avoid the federal law, because that way they could threaten you and tell you things that are not legal in an attempt to try to get you to pay. Okay, but so when this person says they have payday loans and they moving from one collector to another, which means it may have been sold, and they're still trying to bother them. But the bottom line is this: we're going to call this person, and they don't need to worry if their income is Social Security or pension. It's protected. They're going to be fine. Now, I don't know where you are in the country. I hope you're warm. You're not too cold. So I talked to someone earlier today, a nice lady from Oklahoma City, and I said I would talk about her file at the beginning, her case at the beginning. She has about I think she said she had about 30,000 in unsecured debt, and her income was a little bit over, right around $3,000, a little bit more than that a month, a pension and Social Security. But she was way behind on her house payment, and She didn't know what her house was worth, so looked it up, typed in the address, and Zillow said it was worth about 220. And there were several websites that said it was worth in that range, but it possibly wasn't worth that much. And she owed about 140,000 on it, but she was behind around 50 or 60,000 dollars in payments. She had bought it on a land sale contract, and then the party she bought it from had passed away, and now the kids had it. The kids wanted to get paid, and they were going to file foreclosure, or they had filed foreclosure. And so I told her she had several options. Um, she had no way to catch up on the missed mortgage payment. That was 30 or 40 or 50 to 60,000, around $60,000. I said um, she could look at filing a Chapter 13, which is a bankruptcy that would stop a foreclosure, but then you have 5 years to catch up on the missed mortgage payment. But then the payment in the Chapter 13, she'd have to make her regular mortgage payment, which was going to be around $1,100, including the current property taxes. Plus, she'd have to make a payment to a Chapter 13 trustee to catch up on the $60,000 in arrears she owes on the house. And that could be probably at least an extra $1,200 or $1,300 a month. And not only that, the trustee's probably going to charge a fee. His commission is going to be probably 10% of her payment. So, it could be may not make sense. I told her to, find out what the home is worth. It might make more sense to get the home on the market and sell it and come out with any equity. Now, if you talk to a realtor and told her if you talk to a realtor and find out the home's only worth 150 or 160 or 170, it maybe just makes sense not to do anything, just let it get foreclosed on. Now, what about this other debt she has? She's got like a 30,000 in other debt. She doesn't really need to pay that. Um, she could stop paying that. But the bottom line is, could she afford the payment for the Chapter 13 if she decides to do a Chapter 13 to stop a foreclosure? And she may not be able to. But we don't file bankruptcy, but I filed tens of thousands of bankruptcies in the past, so we know how to steer people. I told her to. She had an attorney, and she gave me the name. I looked him up on the internet. He does all kinds of things, but bankruptcy isn't his specialty. And I told her she probably would. If she's going to look at a bankruptcy, especially a Chapter 13, she'd want to go to an attorney that just specialized in bankruptcy. There's a lot of attorneys that specialize in bankruptcy. They know what to do, most of them. Okay. So that's the person in Oklahoma City we talked to. I don't know if there's not too many people on the chat. I don't know if there's a problem. Please tell me that if you can hear me, if you hear me okay. Maybe it's just because it's so cold everywhere. Everyone's trying to stay warm. So, here we go. Now everything sound is good. I'll read these notes that you put on and see if there's notes on the questions that you've got. Thank you. Good. So, this person contacts us from Alabama. Husband is disabled. We are behind on medical bills and owe the place that sends his supplies and food by $900. Well, you know, one thing helps can't do. We can't put more money in your pocket, but what we can do is tell you what bills you don't have to pay and stop them from bothering you. Now, once in a while, we can put more money in your pocket. Sometimes we'll tell people about uh, benefits they may have, veterans benefits if you served in the military during time of war. But in this person's case now, his husband is disabled. We're going to tell this person that his disability income is protected, and if you're paying any credit card debt, you could stop paying it and have that money available for your food. And if you've got some medical bills you can't afford, and if he's on Medicaid or Medicare, they're paying most of the medical bills. If you can't afford to pay the 20% or whatever that you balance you might owe, you could stop paying that. They really can't do anything to collect from you. But if you owe other creditors, you can stop paying credit cards or other debt. And maybe if you have to stop paying this other debt, you're going to have enough money for your basic needs for the food and the current medicine that you need. Okay? So this person contacts us from New York. They're 74 years old. They get 1,600 in Social Security and pension of around 2,500 bucks. And let's see, one of our paralegals, first thing she says is about this person, such a sweet lady. All our clients are sweet because I see that all the time. Anyway, uh, it says was simply curious about us. They originally called on January 8th. Was simply curious about us and needs help with credit card bills she cannot pay. Yeah, if you're curious about helps, don't hesitate to call. We'll go over your situation. A lot of people call us 2 or 3 or 4 or 5, 6 times before they decide our help. Okay? And she goes on. The notes go on to say, almost wasn't able to pay her rent because she was paying them instead. In other words, the credit cards. We informed her of her rights, that she didn't need to pay the credit card debt, that her other income was protected, and she could use that money to pay her rent and her food and her medicine and her needs. She has a son she is very proud of and how hard he works. And we sent her an info packet. We can send stuff to the mail about helps, but frankly, you can learn more about helps by listening to our YouTube videos or looking at our website than anything we would ever send you. So she called back again on, looks like today, and talked to one of our attorneys. We read what we did, explained again. She apparently looked at what we'd sent her originally. It says she banks with a credit union and owes them for a consolidation loan that she really wants to continue to pay. You could do that. You don't have to, but you could do that. And so that's what she's going to do. They take out automatic payments. She is happy with that. We discussed that she didn't want to pay, but for now, she wants to keep the credit union. In other words, she could change her mind if she decided she couldn't keep the credit union bill and let it go back. She gets Social Security benefits and a private pension. She has not filed tax returns for 3 years. She may not be required to file, but if she is required to file and she owes up, she can probably get on what's called currently not collectible status. We have an email that explains that. Okay, and it looks like she enrolled in helps today. What about an arbitration agreement? Well, okay, if someone has sued you and you decided or you came to a resolution on the debt, you don't have to pay it. If your income, Social Security, or pension, or disability, or VA benefits, you don't have to comply with the arbitration agreement. Okay, that's an agreement to pay the debt. But if you can't do it, there's nothing they can do. I mean, if they have a judgment and they try to collect, they can't take your Social Security, they can't take your pension. And as I explained, the law says that twice the amount of your federal benefit, like Social Security, deposited into a bank account is protected from garnishment, regardless of what other funds are in there or where they came from. So I talked to someone earlier today, and the person got they had about 1,500 in Social Security, and then the husband had about 2,500 in Social Security. And I asked him, I said, do you have separate bank accounts? He said, no, same bank account. Well, I said, then if his Social Security is 25 and yours is 15, that's what is that? 25, 30, $4,000. Okay, twice that amount in deposit in your bank account uh, is protected. If they were going to get a judgment and they tried to garnish your account, 4,000 times two is 8,000 in the bank account is protected from garnishment. Now, the husband got a small pension. It was just less than $200, but her name was on that too. That account. It was a separate bank account. And I said, well, you want to get your name off of that account because they could garnish that because since it's not a federal benefit that's going in there, they could garnish that and your name is on that account. And she's going to take steps to get her name off of that. Now, if they did garnish it, they could probably get it back because he could go to court and file a challenge to garnishment or claim exemption, show the court that it came from a protected source. The court would order it be released. But you'd save the headache by just getting your name off that account. Okay? Okay. Yeah, if you have any questions, put them in the chat. We'll deal with them there. Um, so someone asked about a 1099-C. Dottie does. Um, we've got videos that talk about 1099-Cs. What that is if you don't pay a debt and it's over $600, the collector is supposed to send a notice to the IRS saying that you didn't pay this debt and therefore it should be ascribed to you as as income upon which you pay taxes. Okay. Well, if you're not required to file tax returns, then you probably can just forget about the 1099-C. The IRS doesn't follow up on those. If it did, you could deal with it later. But even if you did file taxes and your income is under around 2,500 if you're single or 3,500 and you're a married couple, likely you can qualify for what's currently not collectible status with the IRS and not have to pay taxes. We can give you information on that. Okay. Person contacts us from Pennsylvania. I spoke to one of our paralegals that says about the fact many years I paid my credit cards on time, no late payments. I became disabled and I'm now retired. When I knew I was going to fall behind, I contacted a financial advisor. Looks like Beyond Finance. At that point, all my at that point all cards got behind. They focused on a loan. I paid it off. Uh, my debt is now credit cards. She lists her credit cards. I'm scared about. I own nothing. I own nothing. I rent and get help. I'm scared. I can't afford a lawyer. I'll be 65. I'm helping my grandkids. May have been sued. If you're enrolled in a debt management or debt settlement company like Beyond Finance, and there's scores of these companies out there helping people. And if you're a senior getting Social Security or a pension or disability or VA benefits, if you enroll with one of these companies and you're paying them, the question I have for you, did they tell you when you enrolled with them that your income was protected, that no one could touch your Social Security, and that it was protected in your bank account, and that there was a way to stop them from bothering you, the creditors? If they didn't tell you that, they weren't giving you complete information. Why didn't they tell you that? If they would have told you that, you would have realized you didn't need their help and they wouldn't be making money off you. So we talked to a lot of seniors that some of them were put into utter poverty, making a payment to um, a debt management or debt settlement company, a profit or nonprofit, for debt they can't afford to pay. Okay. Um, So Penny asked, with limited income, only Social Security, what suggestion can you help me when I owe back taxes I can't afford to pay? You probably don't need to do anything. What would happen, the most the IRS would ever do, and it's doubtful they would do this, honestly, they would send you a letter saying they intend to offset 15% of your Social Security after 60 days. But that would give you enough time, Penny, that would give you enough time to contact the IRS and get on what's called currently not collectible status. We have an email on how to do that. I mean, you could do that now if you wanted to, but you really don't need to, because if your only income is Social Security, IRS computer system knows that. They may send you notices, but we don't see them actively trying to offset money from our clients who are getting Social Security for past income taxes due to the IRS. Now, if you owe the state, you don't need to pay them because the state cannot take your Social Security or your pension. It's protected, just like it's protected. Your income is protected from a credit card. Now, the IRS can't offset 15% of your Social Security. Like I said, it's rare they do that. We don't see the IRS going after a person's pensions. They legally could, but they don't do it. Remember, we deal with seniors that are modest or lower incomes, and the IRS, the computer system knows that they're not going after your pension, and it's very doubtful they're going to go after your Social Security. So you probably don't need to do anything about it. Okay, but if you wanted to, you could apply for currently not collectible status. Remember, if you have any questions or concerns when you listen to me, there's nothing wrong with calling us on the phone. Number below, where right here, 855-435-7787. 855-HELPS-US or helps us. And we got paralegals and attorneys that can talk to you. We'll go over your situation. We don't turn anyone away that needs the help that we provide. This person contacts us from Florida. Good morning. I'm seeking your help because I'm in financial hardship due to limited financial resources after losing my husband 3 years ago. My only income is Social Security, they write. And I joined a debt settlement plan a year ago that only made my situation worse. Yeah, that a good example. When this person joined this debt settlement company, they never told her that her Social Security was protected, that she didn't need to pay the debt. No, they don't do that. Instead of helping me, my credit score tanked from not paying my bills. I now have 4 collections coming after me, and one is suing me for $8,000 when I only owed $1,740. I heard you last night on the show on YouTube, and it was such a blessing to hear that there is good people out there that are willing to help us. Yeah, we're yeah. Helps is here to help you. HELP stands for Help Eliminate Legal Problems for Seniors. And we want you to call if you have a question, or if you're like this person, that their income is Social Security, they're with debt settlement, they owe this debt, they were never told their income was protected, and they didn't need to pay the debt. See, before I started HELPS, I filed, I'm an attorney since, 1978. In 1986, I started practicing just exclusively bankruptcy. And so I probably filed between 30 and 40,000 bankruptcies and started HELPS in 2012. And my old bankruptcy firm is still going strong. They refer HELPS a lot of cases. But when I met with seniors, I talk to them and I tell them, I say, well, you realize, of course, maybe you don't, you realize that your Social Security is protected, so is your pension. And you really don't need to pay this debt. But the problem is if I sent them home, and they couldn't afford to file bankruptcy, they didn't need to file bankruptcy, but if I sent them home, creditors could call them and make their lives miserable. And so HELPS was started under the federal law called the Fair Debt Collection Practices Act. And one provision of that law is it says if you're represented by an attorney, then collectors have to communicate with the attorney, not you. And that's what we do. When people find out about us, they call us on the phone. We're going to ask you a bunch of questions. Where you live, how'd you find out about us, what your income is, married or single, buying a home, renting, buying a car, own a car, have you been sued? A series of questions, and then we're going to read you what we do. And then if you decide to enroll, you can call back. We may send you emails that talk about your situation, and you can call back. Some people call back 2 or 3 or 4 or 5 times. And then when you decide to enroll, uh, um, we don't turn anyone away. The cost is minimal. Most would be $40 for 24 months, then $20 for 24 months, then free thereafter. It could be $30 for 24 months, 15 for 24 months, free thereafter, or $20 for 24 months, $10 for 24 months, free thereafter. Um, but we click a button while you're on the phone and you get enrolled immediately. So you don't fill out any form. Okay, you don't need to worry about a form. We can talk to you on the phone and roll you over the phone, and then you get us the creditors. You can text them, fax them, email, or mail them to us. We're going to send them out a cease and desist letter. We do that within 24 to 48 hours, so they don't bother you. In the meantime, if they were to call you after you enroll, you tell them contact my attorney helps. Here's their number, and then tell them not to bother you anymore, and then hang up the phone. And then when you get us the creditors that you don't want to pay anymore, we're going to send them a cease and desist letter. They're going to leave you alone. And we're going to tell you can call us how often you need to call us. You can call us every day. If you ever have a question, you're concerned or worried, we want you to call. If I have funds, Connie asked, if you have funds from another source in your bank account, could the debt collector get that money even if it's below the, no, okay, the way that law works, Connie, is that if someone's, you don't have to worry about money taken out of your bank account unless someone were to sue you and get a judgment. And then if they know where you bank, they could file a writ of garnishment. And now if your bank gets a writ of garnishment from a creditor that has a judgment, then what they do under the law is they have to examine where your money came from. And if you got money from Social Security, let's say it was $1,500, they can tell that it came from Social Security or a federal pension, um, or a VA benefit. And then whatever that money is, they times it times 2. So whatever you got within the last 60 days, usually it's twice that amount. And they protect that sum regardless if there's other monies in there. So if you had money in there from another source, 500 from another pension, or 500 from a gift from a kid, or something you sold on eBay, or something, whatever, as long as it's less than twice the amount of your federal benefit in that account, it's protected. So it doesn't matter if the funds came from another source, it's protected. But you don't even need to worry about it unless you've been sued and there's a judgment. And you don't have to call the bank and ask them about it. There's a department of the bank that deals with garnishments. They know that law, and they know what to do. Okay? Um, so this person contacts us from California. I was improperly served. They got sued, and they said, court papers thrown on my doorstep. Husband found them, 2 sets on our mat as he was walking out. I'm concerned about the court papers. All I have is my Social Security disability. It's not very much. Can I get some help? Well, whoever you are, you can get help. You can always call us. Okay. Um, so I'll answer Jerry's question. Does it work the same if you've already been sued? Yeah. So it does. If we have 5 people call us, Jerry, uh, maybe one has been sued, 3 or 4 are behind, are getting harassed by creditors, and one is completely current on everything. It doesn't matter where you are in this situation. If you've been sued, or you've been sued way back when and there's a judgment, yeah, you can enroll in helps at any point. You don't have to enroll in helps before there's a judgment. So it's the same whether you've been sued, they have a judgment, or not. Your income is protected, period. Okay? So you don't need to worry. So back to this person from California. They weren't served the right way. So what is their option? Well, they could fight the service, but most seniors don't want to do that. They don't know how to do it. Probably need an attorney to do it. The guy who did it, I don't hear this very often, but it does happen. The guy that serves the legal papers He may have tried serving you a few times. You weren't there, and finally said, "Oh crap!" You just threw it on your, and then he gets paid a fee for serving you. So in order for him to get paid, he has to serve you. So that's probably why he threw it on the ground because he wanted to get paid. Um, you could challenge, but you don't need a challenge. If you owe the money and you challenged it and you won, then they could just serve you the right way. Um, because why don't you need to worry? It's just all I have is my Social Security disability income. It's protected. Okay, all forms of social and twice the amount in your bank account is protected automatically. Um, so you would call us on the phone. You know, one of the questions we ask is, have you been sued? If you've been sued, um, and the enrollment helps, you're going to give us the name and you're going to give us a copy of the lawsuit. We just need the first 3 or 4 pages, and we're going to send a little letter to the attorney that sued you, letting them know that your income is protected, that you're not going to do anything. We understand they're going to get a judgment. Remind them of the protected nature of your bank account, although it really doesn't matter because your bank account is protected automatically. Then we call you on the phone, explain to you why you don't need to go to court. We send you an email with links to articles and videos on why you don't need to go to court, why they can't take anything from you, and why you don't need to worry. Okay, so that's what we do. Person contacts us. So when they say, "Can I get some help?" Yeah. If any of everyone's listening to me and you have questions and you're worried, call us on the phone. That's what we're here for. Okay. You're, the only information you're going to hear from helps is good information. Okay. We don't tell people things they don't want, bad things. No, we have good information. And it's kind of funny. There's not a whole lot of people doing that. No one else is doing what I'm doing here on helps. You call a debt settlement or debt management company, they're not going to tell you what you're hearing from me. If they told you that, you wouldn't go to them for business. The National Council on Aging, they get $50 million a year from the U.S. government. Their mission is to protect seniors, those that are, especially those that are suffering financially. You might. Um, on their articles for seniors that are having financial financial problems, do they tell you anything about what I'm telling you? No. They're going to send you. They send you to debt management or debt settlement companies, one or the other. Why? Because these companies donate to them. They don't tell you that your Social Security is protected and that there's a way to stop the creditors from harassing you. Person contacts us from Washington. They're ages 74. They're getting Social Security of $1,736. They're buying a mobile home in a park. He says, I'm 74 due to medical issues and not being able to work for the last 3 years. I had to use credit cards to pay for some medical procedures, co-pays, and unexpected repairs. This is worrisome and it's taking a toll on my health. Please help me. And then they call back on January 23rd. Gets only Social Security, owns a mobile home outright. It's a person's a retired. They had a lot of. He used up 168,000 in his savings to pay the medical debt. Probably didn't need to do that, but that's water under a bridge. Now his credit card and a personal loan debt. He's not at default. We told him what we did, and he enrolled in helps. So what this person's gonna do is send us the creditors he owes money to, and we're going to send him a cease and desist letter. They're going to leave him alone. They're going to be our client literally forever, so they don't have to deal with collectors again. And they're 74 years old, so don't need to worry about it. If you incurred a new debt or if they turn it over to, after you enroll in helps, let's say we send a cease and desist letter out to one of your creditors. You don't hear anything. Let's say 3 years from now, you get a collection notice from a new debt collector about the same debt. Let us know. We'll send a cease and desist letter out to that new debt collector. Let's say you get sued a couple years from now on that debt. Don't need to worry about it. You're going to get the copy of the lawsuit that helps. We're going to send a cease and desist. We're going to contact the attorney that sued you, letting them know that your income is protected. We're going to call you on the phone, explain to you why you don't need to worry. And no, you're not going to need to go to court. So you're going to be okay. That's what helps us here for. So you don't need to worry. Person contacts us from Alabama. The husband is 76, the wife is 64. The debt is in the husband's name. And he gets about $1,800 in Social Security and $1,800 in VA benefits. Wife gets about $1,200 in Social Security and a little bit of VA benefits. And they have $45,000 in debt. They have a free and clear home that they own together. It's worth about $60,000. Something happened. It's just had to happen during a vacation. Snowballed into a huge issues they have now. We sent them an email and told them we could help them if they're interested. They called back and we went over this with them, and they enrolled in helps. Looks like Friday. And what did we tell them? We told them their Social Security was protected, their VA benefits were protected, it was protected in their bank account. Now they had a home that was free and clear, worth $45,000. The debt was in the husband's name, and they lived in Alabama. See, every state has what's called a homestead exemption. Some states exempt all the equity in the home. Some states only a certain amount. Alabama, what do they exempt? I'll explain to you why wouldn't be a problem for them. So they own it jointly with rights to survivorship. The homestead exemption in Alabama is like $33,000. Okay, or $32,900. Well, their home is worth. They may have raised it in Alabama. No, 18,000 for a single person, and they double it for a couple, a little bit more than that. Well, the home's worth $60,000. Well, the debt's in the husband's name, but the home is owned by the husband and wife with survivorship rights. He's 76, she's 64. If they sue the husband, do they sue him? Not yet, but if they sue him and get a judgment, it could become a lien on the home. They then can't take the home because it's owned by both the husband and the wife, and they own it with survivorship rights, which means he's likely going to pass away before she is. He's 12 years older than she is. Then when he passes away, any judgment lien would disappear and the home would be just in her name. They're going to be fine. They don't need to worry. Okay? Okay, here we go. Um, you probably answered this before. I don't care if we talk about the same things over and over again, Tom. So it's okay. We don't mind that. But if you have a joint bank account with your spouse, how does the projection for twice the amount payment work? Well, I talked about it. Okay. If you have a joint bank account and you both get Social Security, let's say you got 1,500 and your wife got 1,200. Okay, 1,512 is, what is that going to be? $2,700. Twice that amount, $5,400 would be protected automatically from garnishment. Okay, so if you have a joint bank account, both Social Securities times 2 is protected automatically. But you don't even need to worry about it unless someone sued you and got a judgment. But then if they were to garnish your bank account and you had less than that in there, it's protected by your bank without you needing to do anything. Don't call the bank and ask them if I'm right, because you'll never talk to the right person. Guaranteed your bank manager won't know the rule. I talked to my bank manager a couple of weeks ago, and he told me, he says, Eric, I remember years ago when you told me this rule. He says, you don't need to ask me again. I do know the rule, but other bank managers don't. There's a department in the bank that does know the rule. So Ms. H asks, when a state is homestead exempt and got a court date from being sued, will the creditor still try and take the property, uh, and can a child be added to the home before the court date being sued? Okay, well, the answer is uh, even if your home isn't exempt, even if you have equity in the home over and above the homestead exemption. Let's say you had a home that's worth $100,000. Let's say you owe $20,000 on it, and the homestead exemption was for the state was $30,000. That means you got $50,000 equity over and above the exemption, what you owe plus what the exemption for your state is, of equity that's not technically protected. Is a credit card company going to try, that as soon as you gets a judgment, are they going to foreclose on the home? The answer is no, they're not going to do that. Can they do that? It's within theory, it's possible. I don't recall it ever happening in 46 years of practice, 20, 30 or 40,000 bankruptcies and helps. They don't do it. Okay. For a lot of different reasons, they don't do it. And I don't want to get into that. The next part of the question is, can a child be added to the home before the court date is, well, in most of the time, yes. That doesn't make sense in every state. But if what you mean is someone's name added to the property as a joint owner with survivorship rights. If someone's on the property before there's a judgment as a survivorship rights, then when you pass away, that property would automatically go to that person. Now, that doesn't make sense to do that all the time, but sometimes it could make sense. Okay? Super Cinema says, Eric, I feel so guilty because before I retired, I spent thousands on credit cards just to survive, but I knew I would never be able to pay them back. Shouldn't I feel guilty for this? We have an email that we call it Guilt and Debt. I could read that to you if you want me to. I think it's a pretty good little email. And here we go. The law defines guilt as moral culpability for an intentionally committed or premeditated act. Hopefully, our choices are guided by principles beyond the law, but it's good to recognize the original intent of this concept. Life does not always wind its way around the path of our intentions. We talked about the recession of 2008 forced many senior citizens to lose their jobs and retire early. I did this email years ago. Carefully planned retirement funds evaporated, home values, seeming bedrocks of financial security, dropped until equity was lost and forgotten. Today, nearly half of American senior citizens live within 200% of the poverty line. The death of a spouse, illness, or any unexpected calamity can push through this cushion pretty quickly. What's left is a series of unpleasant decisions. Add old debt to the mix, and the choice between basic needs and debt repayment gets increasingly difficult. Americans don't want their elderly to suffer. Elected lawmakers on federal and state levels have repeatedly passed legislation protecting the income resources of senior citizens. A senior citizen is not a bad person because he or she can't afford to pay a debt. Lenders are businesses. Lenders know there may be circumstances when debtors cannot repay loans. When lenders loan money or give credit to consumers, they attach an interest rate to the loan. The interest rate exists not only to generate revenue for the business, but to protect lenders from possible risks. They know there may be circumstances when debtors cannot repay loans. While many lenders seek to capitalize on guilt to instigate repayment, loans are contracts made with implied understanding that performance, repayment of the loan is objectively possible. It may not always be possible. Failure to repay outstanding credit or old debt is never a crime. Enforcement of these loans may be sought from civil courts when a debtor is a senior citizen with minimal or exempt assets with protected income. Any court judgment for collection of money owed is effectively powerless. Debt collectors will never inform senior citizens about the laws protecting their income. Harassment does happen. Some collectors will say about anything to intimidate or terrify senior citizens into depleting their limited resources. Attempts to collect debt can feel like the gnashing of teeth of hungry predators, but the law affords senior citizens some effective weapons for self-defense. And then we talk about the Fair Debt Collection Practices Act, the cease and desist letter, uh, uh, guilt over unpaid debt is an understandable struggle. Many of us have a hard time. Okay, and then there's a lot of scriptures from the Bible that talk about debt and about forgiving people because of debt. And so anyway, we have an email that we'd send to anyone about guilt and debt. We don't want you to worry about that kind of thing. I mean, it's not intentional. You never intend to do it. It's just happened. Okay? I sometimes I look at it this way. You would pay it if you could, but you just don't have the money to pay it. Okay? You're not a thief. And it was not premeditated. I mean, you may have, in the back of your mind, you thought, oh, I don't know what I'm going to do at the end. Maybe you're hoping at some point your ship would come in or something would happen. So um, I please don't, it doesn't do any good to struggle over guilt on this stuff. Okay? Call us and we'll send you an email that talks about that. We've got several others that talk about guilt and debt. We don't want you to feel, it's not healthy to feel guilty, okay, on this kind of thing. If I deposit more than 2 times my Social Security in my bank account, will creditors reactivate attempts at collections? Well, okay. Normally, in almost every state, a garnishment on a bank account is like a snapshot in time. Like they get it at 10 in the morning, they look at it at 10 o'clock. And then if you deposit extra money in at 3 in the afternoon, they've already looked at it at 10 o'clock. They've sent it back to the creditor that did the garnishing saying, no, there's not more than twice the amount in the account, your money. So it's a one-time thing. They'd have to do it again. Once again, if you had more than twice the amount in there and it came from a protected source, the amount over that you could file a challenge to garnish or claim exemption to get it released. So, Ms. H.S., after sending helps a copy of the court summons to appear from a creditor, will a cease and desist letter be sent to the law firm that's handling the suit for the creditor that will stop them? Well, if you've been sued, they're going to continue with the lawsuit. We don't send a cease and desist letter. They may have been sent a cease and desist letter earlier. Their remedy is to file a lawsuit. That doesn't mean they're going to file a lawsuit. They could, they may not. I used to give a percentage of lawsuits that would be filed. I don't do that anymore because if I'm wrong, people get upset. But no, what we'll send is a letter to the attorney, let them know that your income is protected. We understand they're going to get a judgment, but that you can't afford to pay it. We're going to let them know that you're not going to go to court. How fast should I get my deceased letter 401 that passed into my name? I don't understand the question. How fast should I get my deceased sister's 401k that passed to me? Oh, how fast should you get it from the bank? I don't know. I don't know. It might take them a week or month or so to process that. Okay. If you're the named beneficiary on the account, it should happen pretty quick. So yeah, if your sister died and she had a 401k and there was some cash in there that you were the named beneficiary, bank should act pretty quick to get that to you. Now, what's pretty quick? I don't know, a couple of weeks. It would be pretty quick. So this person calls us and they were referred to us by another company, and their only income was Social Security disability, and it was a real small amount, $600. Uh, and they wanted to know the difference between helps and bankruptcy. Um, we explained they could no way could they ever afford to file bankruptcy. They may not even file. So there is a company that might help them file bankruptcy, but if their only income, but the filing fee would be half, $325 at least, and plus they have to do a class. They have no need to file bankruptcy anyway. We explained what we did, and because their income was so low, they enrolled in helps. Their fees were waived. Their fees were waived. Person is from Kansas. They got sued in small claims court. They say, I need help. We sent them an email about lawsuit fears, why they didn't need to fear. We call them again on January 13th. Let them know that we don't represent people in court. That's not what we do. Our clients don't need to go to court. They're judgment proof. Then they called again on January 23rd, it would have been Friday, struggling with debt, not current. They're currently being sued. They're disputing it. You can dispute it. If you owe the debt, you don't need to dispute it. They can't do anything to you. We explain that to them. The husband has 5 or 6 credit cards in his name. He's struggling with them. And it looks like they enrolled in helps. There's another question above that I missed. Well, the only question I see that I missed is, um, oh, the weather here in Ohio is treacherous. I didn't read beyond that. I thought you were talking about the weather. If I can get if I can't get the property transferred in my name, can these creditors collect when they find out she passed? Well, okay, I understand your question. What you're worried about is your sister passed. You're supposed to get some money, and you may owe some creditors some money. Um, well, so first, someone would have to have a judgment against you, Cat. If you don't have a judgment, then they can't do anything. But let's say they have a judgment against you. Um, they're not going to know that you're due this money from your sister. They'd have no way of garnishing your sister's estate, okay, or the bank that has that 401k that's going to come to you. Chances of that happen are about the same chances of the Martians coming for dinner this weekend. It's just not going to happen. Okay. Uh, Now, if they do have a judgment against you and you're worried about it, when you get the money, there's different ways you could protect the money. You could cash the check, keep it in cash. You could put it into uh, preloaded debit cards, uh, put it in someone else's name. There's different things you can do so that, no, I don't see you losing the money, um, but there's a chance of you losing that money. Okay. I hope that answers your question. If not, ask it in a different way, but I think I got it. Okay. Um, my next one here, uh, well, I got a short one here. The person calls us from California. The debt is only in the wife's name. We explain how bank accounts are protected. They're renting. They have a lawsuit and they have a court date tomorrow. And we discuss the cost of bankruptcy. She had originally called someone about bankruptcy and they referred her to us because her income was so low. And we explained that she's judgment proof. She didn't need to file bankruptcy. She couldn't afford to file bankruptcy, but she was worried about restoration of her credit. And so, we do have a program called 7 Steps to a 720 Credit Score. After you've been part of Helps for 90 days, we can send you that. You can enroll in this program. We pay 720 Credit Score. We pay that company a fee every month to handle our clients that want to rebuild their credit. You can rebuild your credit. Okay? It's possible to do that. Um, 401 be retitled in my name since I'm a beneficiary. Is there a rush to do that? I don't know if the 401, I don't know if it would be retitled in your name. It wouldn't still be a 401. It would be just cash coming to you. Um, would there be a rush to do that? I don't think there's any rush. I mean, if there's no judgment, see, if a person gets sued and they don't get a judgment, it's going to take them at least a month or 2 or 3 or 4 months before they ever get a judgment. So if there's no judgment, there's no worry. And even if there's a lawsuit, there's no worry until there's a judgment. So you'd have plenty of time to deal with that money. Okay, so it's been an hour, uh, another week. If you have any more questions, you can call us toll free 855-435-7787, numbers below. Uh, we'll be at same time tomorrow. You can also make a comment. We also would like you to press the like button. If you haven't subscribed to our channel, that helps. A lot of people find out about Helps from looking at our YouTube videos. Okay, so thank you everyone for participating and for your good questions today. There's no bad questions for Helps. They're all good questions. Okay, God bless, and I will talk to you tomorrow. And hopefully stay warm, everyone, because there's a lot of cold out there today. Bye.